So, Megyn, as a former lawyer, a Supreme Court expert too, what did you make of this landmark ruling?
Hi, Dan. So I thought the Supreme Court nailed it. And you can believe that whether you're pro-abortion rights or anti-abortion rights. Roe versus Wade and Casey versus Planned Parenthood, decided respectively in 1973 and 1992, were embarrassments. They were embarrassments as a legal matter. The support for the decisions wasn't there, and even prominent legal scholars over here agreed on that. Now, for the first 185 years of our country's existence, this was a matter that was left to the states. Shockingly, there's nothing about a right to abortion in our United States Constitution. And in 1973, the Supreme Court, which was an activist court, changed all that. And it is true that you can find fundamental rights, constitutional rights, even if they're not explicitly spelled out in our Constitution. They are considered implicit, but only when the right you're talking about has a long history in American tradition and culture. And as of 1973, there was no such right here. There was no tradition in America that favored abortion. In fact, for the vast majority of our country's history, abortion was illegal in virtually every single state, including in at the time Roe versus Wade was handed down, where it was unlawful in 30 of the 50 states. There was no tradition that would have supported finding there was any implicit constitutional right. So what does that mean if it's not in the Constitution? It means it's up to the states, as it was for the first 185 years. So now it goes back where it belongs, and we're going to have to duke it out state by state on whether we think there should be no restrictions on abortion, entire restrictions from the moment of conception on abortion, or some middle ground where we maybe say, like the Mississippi law that it was at issue in this case, after 15 weeks, it's no longer okay. And that's how it's going to be, and that's how it should be in a federalist society.